All right, let's talk about this. There are some new laws coming for real estate investors, and it's some scary stuff, folks. They are sending shockwaves through the investing world as we speak. We're going to get to all of those new laws in a moment, or actually a handful of them, because there's way more than I can even talk about. But if you're new here, welcome. This channel is devoted to helping you make money and building financial intelligence. You're going to learn things on my channel that'll set you apart from everyone else, I hope. And you'll learn things that we were never taught in school, never taught in high school. So please subscribe and drop me a comment to let me know that you are new here. Say, hey, I'm new here. Please let me know. I try to respond to every comment that I can. Okay, let's talk about these scary new laws. And I'm going to give you 3 choices as to which state is starting this trend of hurting landlords more and more. Can you guys guess which state it is? Can you? 3 choices. If you're answered California, then you're absolutely right. And once again, it's a reminder as to why I would never invest there. So what in the world is going on in the Golden State? Well, how about this? Listen to this. You can't do a criminal background check on a tenant. You must rent out your property or pay a fine. You must report all of your company's beneficial owners. Boom, boom, and boom. This is a lightning bolt, right? Shooting through the world of investing. And this is bad stuff, folks. Do these sound like an authoritarian bureaucracy? This is the stuff you'd expect from Russia or Cuba, not the United States. California, at this point, probably should just secede from the Union already. This is a disgrace. This is a huge restriction on property and privacy rights, folks. This is really, really scary. So in California, the Oakland City Council outlawed criminal background checks on prospective tenants. Now, the purpose, they said, is to allow the formerly incarcerated to compete for housing and avoid being homeless. Okay, I get it. Now, my great attorney friend Garrett Sutton broke it down like this, and I love the way that he puts this, and he hates California, by the way. He said that any housing provider and any person aiding a housing provider, i.e. a management company, will face stiff penalties for doing a criminal background check. Liability can be 3 times the greater of A, 1 month's rent, or B, actual damages, including damages for mental or emotional distress. A court may actually award punitive damages and attorney's fees. Criminal penalties may also be asserted against the landlord. So tenants' rights attorneys could make hay with this ordinance, going after landlords like crazy. So let me get this straight. If I run a company and I'm hiring, I can do a criminal background check to make sure that the person I'm hiring doesn't have a criminal history. But if I want to rent out my property to you, I can't do this anymore. This is a total catch-22, which I'll explain more of in a moment. And Garrett Sutton goes on a little further to explain that if you own a rental property in Oakland, you most certainly want it titled in the name of an LLC, which would, under normal circumstances, shield you from personal liability. And rather than screening tenants personally, for which these new crazy high penalties would apply, you'll want to use an independent management company for that task. Make sure they're doing it, not you. Because if there's an accidental criminal background check on a prospective Oakland tenant, the management company is going to suffer the consequences, not you. It's crazy, right? But that doesn't sound like a great plan either, because now the management company is liable. Look, landlords have a duty to protect the neighborhood of the rental property from the criminal acts of their tenants. Landlords are routinely held responsible for their tenants dealing drugs on the property, or having an illegal dog that bites somebody, or just name a crime, and we as landlords are responsible. Other tenants or anyone in the neighborhood can sue the landlord, can sue me for the rental property being a public nuisance that threatens public safety. If you've been following our journey on one of our New Jersey properties, you know the story. So in Oakland, you have to rent to criminals, but you're still responsible if they engage in the crime? So if one of your investing guidelines is to avoid nonsensical catch-22s, you may want to just sell your Oakland properties and never invest there again. Please note that that's not the only place either. San Francisco is also considering legislation to ban criminal background checks. What? So I would run, not walk, away from California, because it's going to happen statewide. Here's something else could be coming to other big cities in blue states. San Francisco voters just approved 2 measures affecting real estate rights. The first one aims to deal with the blight of empty storefronts, and no one likes empty storefronts, right? Empty buildings. But the owners of these retail spaces remaining vacant for 6 months or more are going to now have to pay a tax of $250 per foot of linear frontage to the street. And it could be up to $1,000 in later years, and New York City is considering a similar tax. Now, supporters say that landlords care more about the neighborhoods and they only want more rent, that they don't care about the neighborhood. Of course, leaving a storefront vacant for years does not actually constitute more rent. No one wants that. Opponents argue the measure ignores current reality. San Francisco's permitting process for tenant improvements and alterations, as well as new business approvals, they're notoriously old school. And it can take a year or more to get your paperwork through. Bank financing requirements for expensive neighborhood retail spaces, they're called feature covenants, calling for only the most creditworthy tenants. It limits the pool of prospective users, and the rise of e-commerce has certainly not benefited anyone on these brick and mortar spaces throughout San Francisco. Everyone's buying stuff online. And the unintended consequences of this new ordinance in San Francisco will be interesting to watch from a distance because it's going to hurt. What about Detroit, other big cities? The state of California has also inserted their very visible hand into the real estate market. Statewide rent control, folks, has arrived. Properties older than 15 years are limited to annual rent increases of 5 percentage points plus inflation rate over 10%, whichever is less. Owners cannot raise the rent above the new limits to cover capital improvements on these older buildings, which means the Golden State, just like Portland and parts of Oregon, will now have all of this deferred maintenance. The new California law also restricts landlords' ability to evict tenants. If a tenant has occupied a unit for at least 12 months, evictions can be for just causes where the tenant is at fault, and in a limited number of cases where they're not at fault, such as the owner moving in or taking the unit off the market. So when you're evicting any tenant, a landlord must now provide written notice and state whether it's an at-fault or no-fault issue. If there's no fault on the tenant's part, the landlord must provide 1 month's rent money to cover the tenant's relocation expenses. In California, corporate officers and managers can now be held personally liable for civil penalties resulting from minimum wage violations. And, Garrett Sutton likes to talk about personal liability because it always, it's very, very important for you to be covering your personal liability with an LLC. New York has gone now a big step in hurting limited liability companies. And it could totally upset the balance between productive employment and limited liability protection. The top 10 owners of an LLC can now be held personally responsible for violating New York's wage and hour laws. So consider, here's an example, and we'll kind of break it down. You invest $10,000 into an LLC that's doing business in New York. In exchange, you get a 1% interest in the LLC. That's normal, right? 9 other investors hold the remaining 99%, and 3 of them conduct the LLC's business operations. You're a passive investor with no management or authority. You like it that way. That's the type of investor you are. You invested into a limited liability company because your liability is limited to the $10,000 that you invested and nothing more, right? That's the whole historical value of an LLC going back hundreds of years. But New York has now changed the rules. If 3 managers don't pay, for the example, $100,000 in wages, you're now on the hook for the payment, even though you only own 1% of the LLC and had no management authority. You're now jointly and severally liable for the money. This means that if the other 9 owners flee or are bankrupt, you now owe the entire wage claim amount. What if people turn in their shares and all of a sudden, without your knowledge, you're one of the top 10 owners? You're responsible for the whole claim. That can happen. New York's law now totally upends the concept of limited liability, and attorneys are going to be counseling clients to think long and hard about doing business in New York. All this disruption is in the name of protecting workers. That's what they're saying. But what about the owners of these companies? DC is also demanding more from limited liability companies. Their government, with the stated virtuous goal to expose bad landlords hiding behind an LLC, that's literally a quote from them, now wants ownership information on all LLCs, whether for real estate or business, formed in DC or doing business in the district. Just visualize this for a moment. This is one step away from collection of information. And plaintiffs' attorneys are going to be suing not only the LLC, but also the LLC's individual owners. And in some cases, the courts are going to dismiss any personal claims. That would be normal when a liability rests with the LLC. But now, in many cases, the suing of individuals will be used to gain leverage in litigation. And again, the limited liability protection of the LLC will be diminished through government regulation. And we've already seen statewide rent controls on the books and moving in different states across the country. We've already seen it in Portland, Oregon, and these are just some of the laws that are now coming. And again, I come back to my point about investing in blue states versus red states. When you have these incredible regulations, all of this red tape, it makes it inhospitable to do business in those states. New York has spent millions of dollars on television commercials for build a business in New York. It's the greatest place to build a business. Why do you think they're spending millions of dollars on television commercials to encourage you to do business in New York? It's because so many people are moving out of New York to other states like Texas, Tennessee, North Carolina, and Florida. Way more hospitable for business growth. California, everyone's leaving, going to Idaho, and Arizona and Texas. There's all of this migration out of these blue states. Then all these people leave, all these businesses leave, they have to raise property taxes for the people that remain. They make it more draconian every year. They're not going to roll these things back, but some states just did, like Texas. Texas went the opposite direction, which is why I love, why we do so much business in Texas and building our properties there. So Texas, during the November election, made it even better for landlords. They made it even better for us as landlords. And now with a statewide income tax reduction. So the people in Texas said, hey, we've got a lot of business moving here. Yes, we're paying higher in property taxes than maybe we're comfortable with, but we're happy to not be paying income tax. So huge shifts across the country in certain states. Blue states making it more inhospitable for business and landlords. If you're in California, we have so many California viewers of our channel that ask, they're like, well, I live in California. How can I invest? And my point is, don't invest in California, invest out of state. And that's like what our company does. At Morris Invest, we help, I think maybe 70% of our clients live in California and buy properties through us in Texas and other states. Because we make it incredibly easy, cash flowing rental property with tenants already in place, new construction built from the ground up. If you live in one of these blue states that are really draconian, and you were thinking about investing or finding a rental property in your backyard, please don't. I've already warned you about New Jersey. Now I'm warning you about New York, and I've been warning you about California for years. Pay attention to these laws, and they're going to start popping up in other blue states across the country. You watch. Milwaukee, I'm talking to you. I'm talking to you, Milwaukee. I cannot believe. I bet you. I'll put money on Milwaukee over the next few years having some of these really draconian laws pop up. You watch. Who wants to take me up on that bet? So there you go, folks. Some brand new laws that will dramatically affect us as real estate investors.